Alright, ladies and gentlemen, Mr. T here with our 6th Amendment video. Now, ladies and gentlemen, I know what you're thinking. I have no idea what you're thinking right now. I was going to say something cool and witty and funny like I always do, but, you know, I'll save things for the comments. I'll put something in the comments down below here. So, our 6th Amendment, I'm going to jump right in because I kind of got over on the 5th Amendment. I got over on all the other amendments. I might go a little tiny bit over on this amendment. I don't know. But 7th Amendment on, I should be good because that's when we start not getting into the less important amendments. Some of them are really important. But, you know, the Bill of Rights is like the Bill of Rights. So if you watch the FAQ or the frequently asked questions, then you know how important these are. So I'm going to jump right in. What is the 6th Amendment? The 6th Amendment covers, like, you know, the 5th and the 4th cover, or the 5th Amendment covers several things. 5th and the 1st. They cover several things. One of the biggest things, actually the two biggest things are probably speedy trial and right to an impartial jury. Those are probably two of the biggest things. Now, I'm going to dive into what those are. But before I get into that, I want to mention one thing, and I forgot to mention it in the 5th Amendment, but it's the incorporation doctrine. Brought it up in the 1st Amendment videos, and the incorporation doctrine, just a little recap, is basically, it's like the doctrine that states that the Bill of Rights, or the first 10 amendments of the Constitution, do apply to the states. Because pre-incorporation doctrines, like 1800s, or early 1900s too, before and then prior, a lot of people no, the Bill of Rights, the first 10 amendments, only apply to the federal government. However, under the incorporation doctrine, they do apply to the states. All 10 of them do. Now, when I was doing research for the 6th Amendment, each individual part of the 6th Amendment had a different court case that applied it to the states. The last one that finally took all parts of the 6th Amendment, that incorporated it to the states, the final one I could find was in 1968. So as of 1968, all parts of the 6th Amendment do apply to the states. Alright? So don't think like, oh, well, you know, if I get charged with a state crime, there's nothing I can do here because, you know, the 6th Amendment doesn't apply. But it does. As of 1968, and like I said, there was a whole bunch of court cases, and each individual part of the 6th Amendment was picked out, and, you know, yeah, I'm not going to get into it. But the 6th Amendment does apply to the states. Okay? So now that we got that out of the way, what does the 6th Amendment cover? It covers a lot of things. It covers right to a speedy trial. It covers an impartial jury. It covers your right to see the person accusing you of the crime and things like that. So I'm just going to jump right in. Let's get to counsel. So I'm going to kind of start backwards. So one of the rights under the 6th Amendment is your right to effective counsel, or to counsel. Okay? It doesn't say effective counsel in the actual amendment. However, the Supreme Court did add the word effective. Because if you have just counsel, and counsel means like a lawyer, okay? Whenever I say the word counsel in this video, it means lawyer, okay? So whenever you have like counsel or a lawyer, okay, pre-adding the word effective, you know, you could have had Billy Joe down the street who never opened a law book in his life representing you. And that could be counsel. However, the Supreme Court did say that you have the right to effective counsel, okay? Now, two things on that. First off, there's a court case. The court case was Gideon v. Wainwright in 1963. This is actually one of the most famous 6th Amendment court cases. If you type in 6th Amendment, Gideon v. Wainwright is probably one of the things that is, or one of the first things that are going to pop up. Now, not going into the specifics, but basically this gentleman broke into a pool house trying to steal some stuff. They got arrested, and when he was on trial, okay, he says that he asked for counsel because, you know, under the Miranda rights, although, yeah, I think, no, Miranda was in play, and at this time, or it wasn't. I'll put down here if it was or not. But at the time, they said, you know, you have a right to counsel, and he's like, hey, I don't have the money to hire a lawyer, because the gentleman was a poor man. He's like, oh, I'm sorry. He's like, I don't have the money to hire a lawyer. You guys have to give me one. And the state, it was in Florida, the state said, no, you know, this isn't a major crime. It says that Florida law required only lawyers can only be supplied if it was a major crime. Burglary wasn't a major crime. So Gideon, you know, appeals it up to the Supreme Court, and the Supreme Court is like, no, under the 6th Amendment, no matter what crime you commit, okay, you have the right to counsel or a lawyer. Okay, and if you can't afford one, then the state has to give you one. Okay, that's now. On the flip side of that, if you are given a lawyer, so the state gives you a lawyer to use as your counsel, if let's say you get charged with a crime, the state gives you a lawyer, and then you end up being found guilty. You can fight and say that your lawyer was not effective under two things. The first one is the person who is defending you, or your lawyer, had a deficient performance, or the performance he played was like deficient. So like he didn't call in character witnesses, he didn't collect enough evidence, things like that. Okay? If you can prove that your lawyer did that, that's the first step. The second step is that his deficient performance, so he basically didn't do everything he could have to prove you innocent, caused an unfair trial, which means you ended up getting guilty. Okay? You can't say, "Oh, I had an unfair," or "my lawyer wasn't effective," even if you win. Like if you win the case and you're not found guilty, you can't say, "Oh, well, my lawyer was ineffective," because if you're not found guilty, he obviously was effective enough. Okay? And so there's those two things. One final thing on effective counsel is the Supreme Court ruled that you do have the right to represent yourself or waive counsel. Now, here's a couple things on that. The main thing about it is the judge or the jury or whoever's like in charge of you waiving your rights has to say, it's different for each area, but they have to say that you are mentally fit, basically. So someone who is someone who has a mental disability or something like that cannot waive their right to counsel. And there's a few other things that come into play there, like certain crimes and things like that, where you can't waive your right to counsel. Now, a lot of people, especially lawyers who get charged with a crime, generally waive their right to counsel and they end up representing themselves. Okay? Now, one final thing on that is, if you waive your right to counsel and you're in prison, they have to give you access to law books or a lawyer who you can talk with to find out how you can defend yourself. Now, they don't have to give you access to the prison library if you're like in solitary confinement. They just have to give you some access to an ability to, study your case and study what defense you have. Now, moving on. The next major thing is an impartial jury. Now, this one is super, super murky, watery-ish, because an impartial jury, on some cases, can be almost impossible to find. Because, I'll use the Boston bomber as an example, okay? Under the Sixth Amendment, your jury that you have convicting you of a crime has to be of your peers, okay? There's 94 districts inside the United States. If you commit a crime, whatever district you are in, other people of that district are the ones that are going to be on the jury accusing you of a crime or not, okay, or guilty or not, okay? Now, here's the thing. Boston bomber, okay? With the overwhelming amounts of news media we have nowadays, most people who saw the stuff that happened with the bombings and things, they instantly made up their mind on whether this guy was guilty or not. So it's like if you're pulling people from this small area or this district who probably more than likely were affected by this guy in one way, form, or another, how are you going to have an impartial jury? I mean, the guy just set off a bomb in a major area, killing several people and wounding hundreds others. How can you get people from that area to now be impartial? And that's one of the major challenges. Okay? Now, the thing is, though, impartial doesn't mean ignorant or they don't know anything of the crime. People can know what happened and hear things from the news and stuff like that. They just have to prove that they will be unbiased. And again, people can lie, and they do, each district or each of the 94 districts do have kind of their own way of determining if someone's lying or not. And like I said, people can be good liars, and that's up in the air right now. Now, moving on. Two final things under the Sixth Amendment. The first one is, and I'm going to get to this because it's the shorter one, is you have the right to face your accuser. Now, this one has gone back and forth big time. Because there's two court cases, and I'm not going to I'll put their names down here. But the first court case said, and they both had to do with sexual abuse to a child. The first court case did say that the person who actually did the abuse has the right to face the children face to face. Not having a screen in the middle, because the court case, they put a screen up, and the guy's like, no, by you putting that screen up, I can't face my accuser. Okay, the Supreme Court said he's right, and they aren't allowed to have that screen. You have to be sitting in the courtroom facing the person that is accusing you. So that, a lot of people are throwing red flags up, like, well, if someone, sexually assaults a child, and you're now going to have that child sit in the same room as them, that can, totally destroy that child's, mental stability and cause mental harm. And that's where the other court case came in. The other court case, and I'll put it up down here, says that it's okay to use things like one-way mirrors or one-way TVs, so the person who did the crime, who actually assaulted the child sexually, can at least still see them, but the child won't see them back. And like I said, it goes back and forth here and there, and, you know, determining how, if they're allowed to use that TV isn't, you know, if it's a sexual assault on a child, they use it, period. It's not that. It's a case-by-case basis. And the last thing on the Sixth Amendment, okay, and like I said, that's, you could throw red flags up or not, but that's just what the courts have decided. And the last thing is right to a speedy trial. Now, there is under Baker v. Wingo in 1972, the gentleman was held for 5 years before getting a trial. The Supreme Court said that he should have only been there for 7 months. Okay? So he was there for 5 years. They said 7 months would have been the max he should have been there. Now, after that, they set up a speedy trial test, okay, to determine how long you're allowed to be in jail, or how long you're allowed to be accused of a crime before you actually go to court. And there's 4 tests. The first is, how long is the delay? From the time you're accused of the crime or the crime is made public and the time you're actually taken to court. The second one is, what's the reason for the delay? Okay, why are they waiting so long? The third is the time and manner the defendant asserted his rights. So if you're like, hey, I want my trial, okay, the when you say that and how you say that determines when you get your trial. If you're being like for lack of a better term, a dick about it, and you're like, hey, I want my trial now, or I'm, gonna jump ship or something, and you act like that, they can push you back a little. And if you wait up until your up until your year mark or something like that, and you're like, hey, I want my trial now, that could be, they could be like, or if you ask for your trial the next day, they can, say, okay, we're going to push that to the side. And the last one is the degree of prejudice the delay caused you. Now, here's the thing on that, prejudice. They don't mean prejudice as in like if the person accusing you is like of a different race or something. They mean prejudice as in like, if the delay caused you harm to your family because you're the primary, breadwinner of your family and your family's not getting an income now. If, the defendants or the people who were going to testify against you or testify for you or things like that start, their memory starts to fade or they move away. Things like that. Things that the longer the time takes, the worse it can harm you, the person waiting. Okay? Those 4 are going to be determined on a case-by-case basis. And the last thing to add to that, after Baker v. Wingo, in 1974, Congress passed the Speedy Trial Act, which sets time limits for what each crime, how long you can wait between each crime. Okay, so I'm out of time, ladies and gentlemen. I told you I was going to go a little over. 7th Amendment is next, okay? That has to do with, my mind went totally blank. I literally just had a brain fart. But the next is going to be, after that is the 8th Amendment. That's cruel and unusual punishment. I mentioned that in the last amendment. So I got to go, ladies and gentlemen. Already went over my time. Stay beautiful, Americans. And like I said, I never have enough time for these videos because there is so much to talk about. So, ladies and gentlemen, stay beautiful. Love you all, Americans, and peace.